Supreme Court has finally explained why it upheld the controversial election of President Uhuru Kenyatta in the repeat October 26th poll. The judges found in their verdict that there was no need for fresh nominations ahead of the October 26th repeat presidential election and that NASA leader Raila Odinga did not legally withdraw from the presidential race. The judges therefore explained that Raila's purported withdrawal was a mere declaration of his intention, which had no effect on the poll. Our Rita Tinina opens our broadcast tonight with details from the Supreme Court.
After a 9-minute summary judgment on the 20th of last month, Supreme Court judges outlined details of their decision, which upheld President Uhuru Kenyatta's victory in the October 26th repeat presidential poll, paving the way for his swearing in.
The election held on the 26th of October 2017 was credible and met the constitutional threshold.
Former MP Haron Mwau and activists Elef Halifa and John Jomue challenged Uhuru Kenyatta's victory on several grounds, among them failure by the IEBC to conduct fresh nominations ahead of the repeat presidential election.
The nominations for presidential election candidates, which took place on 28th and 29th May 2017, remained valid, and no other nomination was required for the election held on October 26, 2017.
The withdrawal of NASA flag bearer Raila Odinga from the presidential race 16 days to the repeat poll threw the country into uncharted legal territory. Raila wrote to the IEBC withdrawing his candidature.
The withdrawal of the candidate from the 26th October 2017 fresh presidential election could not, in law, have occasioned the cancellation of the elections.
Raila's name remained on the ballot paper, even as NASA supporters boycotted the election. The run-up to the election was marred by violence in NASA strongholds, which saw the IEBC postpone elections in 25 constituencies. The petitioners argued the IEBC failed to conduct elections in all 290 constituencies in contravention of the law.
It is clear that the Commission made its declaration pursuant to the Constitution and pursuant to the law. On that basis, even though those voters in the 25 constituency did not vote, the declaration of the results by the Commission was in perfect accord with the terms of the Constitution.
The petitioners had also challenged the inclusion of all 8 candidates who took part in the August 8th general election in the repeat poll, after the High Court granted the prayer by a Kuruau court seeking to be included on the ballot.
It is our finding that the first and second respondents, and indeed the third respondent, as well as all the other presidential election candidates, bear no fault as regards nominations and the inclusion of all the August 8th candidates on the ballot paper.
The judges dismissed an argument that the United Democratic Party candidate Cyrus Jirongo's name was included on the ballot despite having been declared bankrupt, saying the bankruptcy order had been stayed by the High Court. The judges also cited lack of evidence and dismissed several other arguments, among them claims of irregularities, use of state resources to advertise the government's achievements, voter intimidation by people dressed in army regalia, and allegations that President Uhuru Kenyatta's utterances following the nullification of his win intimidated judges.
And we are speaking for ourselves in this regard, that no judge of this court was intimidated by the choice of words by the third respondent.
That the petitioners have not discharged the burden of proof.
As the highest court in the land, the pronouncements by the Supreme Court put to rest various legal questions and set a precedent that will no doubt be a reference point in future electoral disputes. Rita Tinina, KTN News.
Let's now bring in lawyer Elisha Ongoya to help us understand some of those issues that the 6-judge Supreme Court bench was trying to explain itself on. Thank you for joining us, Bwana Wakili.
Thank you.
How would you describe that full judgment today?
Let me put it this way. First, what we heard from the judges today was an abridged version, a summary of the judgment. Because of the significance of this judgment, I think from what I gather, the judges had to correct any clerical, typographical errors before they released to the public.
Right.
Up to this moment, a few minutes ago, I've confirmed that the full edition of that judgment is yet released to the public, and therefore our listeners must appreciate that what we are all benefiting from is the summarized version. The full judgment will become necessary for us to have a detailed inquiry into the full reasoning of the court.
All right.
The judgment is historically significant because it is pronounced itself on perhaps our most important democratic process, a presidential election process. And that will remain significant in this country for years to come, for decades to come, because election of the president, even in the most mature democracies, even in the West, remains a matter that people don't take lightly. And therefore, when the highest court of the land is pronouncing itself on such a process, that is not a minor matter.
Right.
It's a major matter. The resulting judgment is a major judgment.
Let's get into some of those issues that we did, or Kenyans did here today. Let's start with a bit more information on that issue of the candidate of the NASA coalition, Raila Odinga's withdrawal. What we have learned, he did not legally withdraw from the repeat election. What is the true picture?
I listened to Justice Mokin Charles Wanjala read that portion of the judgment, the same abridged version. Yes. And I think what is playing out in the media is when the judge was summarizing the submissions by some of the parties before he made the court's verdict. My listening to the judge was clear that the judge found that they could not compel a party to continue participating in the election, right. And therefore that letter was a formal withdrawal from the process. When we get the final copy of the judgment, we'll be able to cross-check this fact. But based on my recollection as I listened to the judge, it was clear that that letter constituted a formal withdrawal from the process.
All right. What's your take on the issue of nominations, which the judges did talk about, saying that the repeat election did not necessitate another fresh round of nominations?
Without saying it, the judges themselves acknowledged that they were the authors of this confusion by their 2013 decision. They said that, number one, that decision of 2013 was an obiter dictum, as was found by the High Court in the Ekuru Au Court case that we now call it. Right. And number two, the judges also found that even if it was not obiter, they say it was by incuriam. It was a declaration in error. Now, the frustration with this is that they are saying it after the fact. And therefore, certain decisions with far-reaching governance consequences had been based on that era of law. Let's take a few examples. When the IEBC itself first declared who would be the candidates in this election, it declared only two people, Uhuru Kenyatta and Raila Odinga. When Raila Odinga declared his withdrawal from this process, he founded that withdrawal on that judgment. So we have the IEBC declaring two candidates based on that judgment. We have Raila Odinga declaring his withdrawal based on that judgment. Ekuru Court had suffered the inconvenience of having to go to court before his name is put on the ballot paper, courtesy of that judgment. The other candidates who are then put on the ballot box on the 11th hour didn't have the privilege of campaigning for 60 days, courtesy of that error. And therefore one sees that the error was not a minor error. It was a fundamental error that I hope the Supreme Court would have spared at least a paragraph or two to apologize to the nation for the inconvenience caused by that error. Safe to say that, well, the Constitution itself says that the Supreme Court is not bound by its previous judgments. And true to that, it departed from its statement in the 2013 decision that if one of the candidates were to withdraw from the election, then a fresh nomination has to take place. Safe also to point out that it departed from its 2013 decision that the only candidates in such an election would be only the winner and the runner-up.
Is it safe to say that it is NASA who were hurt a bit more by that error, as you call it?
Well, the nature of a presidential election, unfortunately, is that it affects every citizen in every corner of this country. And one would say the country has suffered the consequence. You saw throughout that process, there were moments of high anxiety because of decisions based on that judgment. To that extent, I would say the entire country was hurt by the errors and omissions that the Supreme Court visited on the Republic by virtue of the 2013 judgment.
All right. In terms of, they're also deliberating on the issue of, 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 the issue Kenyans being put in a moment of being scared in the whole electionary period. They did absolve, however, the IEBC of any wrongdoing and the state agencies. What is your take on that?
Again, yes, it's true that the court absolved the IEBC and all state agencies from any wrongdoings, but didn't blame anyone. They blamed unidentified people or political actors. And that roundabout way, it appears to me to have been a safe way that the court was playing without confronting the issue, which is a characteristic Kenyan way of dealing with issues, where you get around an issue in a roundabout way without confronting it. What is sure, however, is that citizens of 25 constituencies, therefore, the last time they participated in choosing the chief executive of this country, effectively, lawfully, was in 2013. It'll mean that in terms of regular elections for them,
yes,
it has lesser practical significance than it has for other citizens. It's an issue that we must continue pondering over as a country. The court has pronounced itself. We must respect that verdict of the court in the interest of enabling our institutions derive confidence and mature themselves. But we must continue the discourse around this question so that perhaps one may say, never again should it be that a citizen of this country is prevented from exercising the right to a government of his choice, or at least participating in getting a government of his choice.
On the grounds of each of the 290 constituencies having to participate in an election of a president, where does this judgment leave that particular issue?
I can sympathize with the pragmatic approach of the judges. They say that if we become too puritanical with each of the 290 constituencies, then you open it up to possible mischief, where somebody in a far removed corner can orchestrate mischief in a particular hamlet just to ensure that the electoral process is nullified because of that alone. So they were being pragmatic about it. But there's a broader governance question to this, that where you have 25 constituencies who would, for the next 5 years, be looking at a president wondering, so who elected that one? It presents a much bigger question of public participation. It presents a much bigger question of inclusivity in the governance process, and this is an issue we cannot run away from as a country of well-meaning citizens.
Final question. Where does this leave this country in terms of electoral justice? There's a section of Kenyans fronting an argument that, you can't, those Kenyans that you're talking about, you can't go to the highest court in the land to get electoral justice. On the other hand, the continent was praising the Supreme Court of Kenya for delivering a momentous judgment on the 1st of September. Who is fooling who?
Unfortunately, Ben, and all our listeners must know this, that we live in what is called an adversarial legal system, where two adversaries come and wrestle, and the court cannot sit on the fence. The court must only pronounce one of them as a winner or a loser. Unfortunately, in a contest of that nature, whoever loses walks away with some element of bitterness, like any other loss. We cannot give up on this process. These Kenyan citizens who took the bull by the horns and went to this court have helped advance the growth of our law to some level. And they have helped give us an opportunity again to interrogate the place of the Supreme Court in our electoral justice. That way, we continue growing our institutions. So I don't want to be too pessimistic to say that Kenyans should give up on electoral justice completely. We must have a robust debate. That we must have. Somebody has pronounced here earlier that there may be elements of dishonesty in the whole process. This can only be resolved through a robust discourse. We must continue, but that discourse can only be carried forward if people take the courage of the citizens who went to court in these kind of circumstances and gave the court an opportunity to pronounce itself, and consequently gave us an opportunity to interrogate the level to which we have grown as a country in terms of building the philosophy of law on elections and electoral justice.
All right. Thank you so much, Lawyer Elisha Ongoa, just helping us understand some of those issues that the highest court in the land was trying to explain the reasons why. The full judgment, the abridged version of that, as he has explained to us. Thank you for staying with us.